11th of January, 2001. McAlester, Oklahoma. The H Unit at Oklahoma State Penitentiary logs an execution at 9:21 in the evening. Wanda Jean Allen becomes the first black woman executed in the United States since 1954. The Clemency Board had voted 4-1 against mercy 3 weeks earlier. Fewer than 2% of all condemned inmates are women. Fewer than half of 1% are black women. 7 cases span 3 decades, 4 states, identical charges. 3 women died. 4, wait. Courtrooms promised finality. The dockets tell a different story. Appeals stretched across 20 years, forensic disputes, consular violations, mental health mitigation buried in sealed records. Victim families attend hearings, decade after decade. The law treats the rarest defendants through systems that vary wildly across state lines. This is that record. Oklahoma Pardon and Parole Board. Clemency Docket, December 2000, shows agenda item, vote tally and denial reasons. Oklahoma County District Court carried a heavy docket in 1989. Wanda Jean Allen appeared for sentencing on first-degree murder charges stemming from the December 1988 shooting death of Gloria Jean Leathers outside a convenience store in Oklahoma City. The jury returned a death verdict. Allen had a prior manslaughter conviction from 1981. The Oklahoma Court of Criminal Appeals affirmed her sentence on direct review. Clemency is the executive power to commute, pardon, or reprieve a sentence. It exists as a final safety valve when courts have exhausted their review. The Oklahoma Pardon and Parole Board holds authority to recommend clemency to the governor. In Allen's case, defense counsel submitted letters documenting untreated mental health concerns and a measured IQ suggesting intellectual disability. The American Civil Liberties Union wrote in support, citing serious cognitive impairments. On the 15th of December, 2000, the board convened. 4 members voted to deny clemency. 1 voted to grant. The governor declined to intervene. Execution was set for January. Public observers expected rarity would trigger mercy. The file showed otherwise. If clemency serves as the last protection against irreversible error, why did documented mitigation fail to move the board? Harris County Trial Court Judgment, November 1988, specifies capital murder conviction and unanimous death recommendation, Houston, Texas. November 17, 1988, a Harris County jury convicted Frances Elaine Newton of 3 counts of capital murder for the April 1987 shooting deaths of her husband Adrian, 7-year-old son Alton, and 21-month-old daughter Farah. Prosecutors alleged insurance motive. The defense contested ballistic evidence, arguing the weapon linked to Newton differed from the murder weapon based on residue patterns. Mitigation is evidence introduced at sentencing to reduce culpability or recommend a lesser punishment. Newton's attorneys presented testimony about her background, lack of prior violent history, and character witnesses. The jury deliberated and returned a unanimous recommendation for death. The Texas Court of Criminal Appeals affirmed on direct appeal. Newton filed state and federal habeas petitions challenging forensic procedures and prosecutorial conduct. Clemency petitions reached the Texas Board of Pardons and Paroles in late 2005. The board voted 7-0 against commutation. Governor Rick Perry declined to grant a reprieve. Newton was executed by lethal injection at the Huntsville unit on September 14, 2005. Victim advocates attended. Some expressed relief. Others questioned whether forensic uncertainties had been fully resolved. When capital sentencing depends on expert testimony about gunshot residue and ballistics, does finality rest on science or jury confidence? Death Penalty Information Center. Statistical Summary 2000 confirms fewer than 2% of death row inmates are women. Subset of black women approximates 0.4%. Across the United States, women represent fewer than 2% of death row populations. Black women constitute roughly half of 1%. Between 1977 and 2013, only 17 women were executed nationwide. 3 were black. The numbers alone signal rarity. Rarity, however, does not guarantee uniformity. Life without possibility of parole, abbreviated LWOP, means exactly that. Confinement until natural death with no parole board review. Some states offer LWOP as a plea alternative to capital trial. Others apply it after commutation. Appeal posture describes where a case stands procedurally. direct appeal, state post-conviction, federal habeas corpus, or clemency stage. A defendant on direct appeal has not yet exhausted state court review. A defendant in federal habeas has cleared state courts and now challenges constitutional violations in federal district court. The 7 cases examined here span Oklahoma, Texas, Louisiana, and Georgia. Sentencing years range from 1989 to 2019. 3 women were executed. 4 remain on death row with varying appeal postures. Offense details are comparable. Murder during felony, multiple victims, or aggravated circumstances, yet outcomes diverge sharply. One state executed 2 women within a decade. Another has not carried out a female execution in over 60 years. If the law applies equally, why do identical charges produce such different endpoints across state lines? Texas Department of Criminal Justice Execution Summary, June 26, 2013. Official record of Kimberly McCarthy execution, Dallas County, Texas, November 24, 1998. A jury convicted Kimberly LaGale McCarthy of capital murder in the stabbing and robbery death of 71-year-old Dorothy Booth in Lancaster. Prosecutors presented evidence McCarthy posed as an Avon representative, entered Booth's home, attacked her, stole jewelry and her Mercedes-Benz. McCarthy had prior convictions for robbery. The defense introduced mitigation testimony regarding McCarthy's history of drug addiction and trauma. The jury recommended death. McCarthy's direct appeal and state habeas petitions were denied. Federal habeas review proceeded through the Northern District of Texas and the Fifth Circuit Court of Appeals. The United States Supreme Court declined certiorari. McCarthy filed a final clemency petition with the Texas Board of Pardons and Paroles in June 2013. The board unanimously recommended against commutation. On June 26, 2013, McCarthy was executed at the Huntsville unit. She became the first black woman executed in the United States since Frances Newton in 2005, and the 500th person executed in Texas since 1976. Booth's family members witnessed the execution. They described a sense of closure after 15 years. Between Newton's execution in 2005 and McCarthy's in 2013, Texas carried out 129 other executions, all men. Does the 8-year gap between female executions reflect rarity of female capital crime or prosecutorial and jury reluctance to seek death for women? Louisiana Department of Public Safety and Corrections, Death Row Roster 2024, lists Antoinette Frank among active death row inmates, New Orleans, Louisiana, September 1995. Antoinette Frank, a New Orleans Police Department officer, was convicted of first-degree murder in the killing of off-duty officer Ronald Williams and restaurant employees Ha and Quang Vu during a robbery at the Kim An restaurant. Prosecutors alleged Frank, while on duty, conspired with an accomplice to rob the establishment. Williams, who was working security, confronted them. Frank shot him. The Vu siblings were also killed. Frank's case drew intense media attention because of her status as a police officer. The defense argued ineffective assistance of counsel and later raised claims about prosecutorial misconduct. The Louisiana Supreme Court affirmed her conviction and sentence on direct appeal. Frank filed post-conviction relief petitions in state court, which were denied. Her case entered federal habeas review. As of late 2024, Frank remains on death row at the Louisiana Correctional Institute for Women. Louisiana has not executed anyone since 2010. A de facto moratorium exists due to litigation over lethal injection protocols and difficulty obtaining execution drugs. Frank's appeals continue in federal court. Her case has been pending for nearly 3 decades. The Vu family and Williams's relatives have made periodic public statements expressing frustration over the prolonged legal process. One family member testified at a legislative hearing in 2019, asking whether justice delayed becomes justice denied. Louisiana's death row holds fewer than 70 inmates. Frank is one of 2 women. When a state ceases executions but maintains death sentences, does the punishment become indefinite incarceration under threat, a sentence neither the jury nor the statute contemplated? United States Supreme Court Order, November 13, 2018, denies certiorari in Carty v. Davis, Gatesville, Texas. The Patrick L. O'Daniel Unit houses Texas's female death row. Linda Carty, a British citizen, was convicted on February 21, 2002 in Harris County of capital murder in the abduction and killing of 25-year-old Joanna Rodriguez. Prosecutors alleged Carty orchestrated the kidnapping of Rodriguez and her infant son as part of a scheme to claim the baby as her own. Rodriguez was found bound and suffocated in the trunk of a car. Carty maintained her innocence, asserting she was framed by drug dealers she had worked with as a confidential informant for the Drug Enforcement Administration. The defense raised claims of ineffective assistance of counsel and argued Carty's consular rights under the Vienna Convention were violated. British consular officials were not notified of her arrest in a timely manner, denying her access to assistance. Carty's direct appeal was denied. State habeas corpus proceedings followed, then federal habeas review in the Southern District of Texas. The district court denied relief. The Fifth Circuit Court of Appeals affirmed. On November 13, 2018, the United States Supreme Court denied Carty's petition for certiorari. Her case remains under active appeal with ongoing clemency advocacy led by human rights organizations in the United Kingdom. Rodriguez's mother has attended multiple court hearings over 2 decades. She has stated publicly that the legal delays prolong her grief. Carty's case illustrates how international treaty claims intersect with domestic capital procedure. The Vienna Convention issue appears in a small subset of death penalty cases involving foreign nationals. Courts have generally ruled that treaty violations do not mandate relief unless prejudice is proven. When a defendant exhausts all appeals and the Supreme Court declines review, what procedural avenues remain, and do they offer genuine hope or mere delay? Texas Department of Criminal Justice Offender Information page 2024 confirms Erica Shepard, active death row status, Harris County, Texas. March 3, 1995. Erica Yvonne Shepard was sentenced to death for the June 1993 murder of Marilyn Sage Meacher. Prosecutors presented evidence that Shepard and an accomplice robbed Meacher, stole her car, and bludgeoned her to death with a 10-pound statue. Shepard was 19 years old at the time of the offense. The defense argued Shepard was not the principal actor and should not receive the same sentence as her co-defendant. Mitigation testimony included Shepard's age, family background, and claims she was coerced or manipulated by the older accomplice. The jury recommended death. Shepard's direct appeal was affirmed by the Texas Court of Criminal Appeals. State habeas proceedings were denied. Federal habeas review has been ongoing for years with multiple motions and evidentiary hearings. As of 2024, Shepard remains on death row at the Patrick L. O'Daniel unit. Her case has generated periodic advocacy campaigns focused on her age at the offense and arguments that younger defendants merit special consideration. Texas law at the time did not prohibit death sentences for those over 18, though subsequent Supreme Court rulings in Roper v. Simmons, 2005, barred execution of offenders under 18. Meacher's family has issued statements over the years expressing that the prolonged appeals process prevents them from moving forward. One relative testified at a parole board hearing that every new legal filing reopens wounds. Shepard's case has been on death row for nearly 30 years. The median time from sentence to execution in Texas is approximately 11 years. When a death sentence lingers for 3 times the median duration, does procedural thoroughness morph into a separate form of punishment, one the statute never defined? NAACP Legal Defense and Educational Fund, Death Row, USA Report, Winter 2024. Lists Tiffany Moss among 34 women on death row nationwide, Gwinnett County, Georgia, June 6, 2019. Tiffany Moss was sentenced to death for the murder and concealment of her 10-year-old stepdaughter, Imani Moss. Prosecutors alleged Imani died from starvation and abuse, and her body was burned in a trash can. Evidence presented at trial included medical examiner testimony about malnutrition and evidence of systematic neglect. Moss chose to represent herself at trial, despite warnings from the court about the risks. She presented no defense case, called no witnesses, and made no closing argument. The jury convicted her, and after a brief sentencing phase, recommended death. Georgia law requires judicial concurrence with a death recommendation. The trial judge imposed the sentence. Moss is one of only 2 women on Georgia's death row. Georgia has not executed a woman since 1945. The state has carried out 76 executions since 1977, all men. Moss's case is in early post-conviction stages. Her appellate attorneys have raised claims of trial court error in permitting self-representation without adequate mental health evaluation. Amani's biological mother and extended family members issued statements following the sentencing, describing the unimaginable loss and expressing hope the legal process would conclude swiftly. Georgia's death row is housed at separate facilities for men and women. Moss is held at Arundel State Prison. The state's lethal injection protocol has faced legal challenges, creating uncertainty about future execution dates. If Georgia's historical pattern holds, no female executions in nearly 80 years, does Moss's death sentence represent symbolic severity, or will the state break precedent? And if self-representation claims succeed on appeal, does the case return to square one? Amnesty International Urgent Action Report, December 2000, documents international appeals for clemency in Allen case, December 2000. Amnesty International issued an urgent action alert regarding Wanda Jean Allen's impending execution. The organization cited concerns about intellectual disability, inadequate legal representation, and failure of the clemency process to account for mitigating factors. Letters poured into the Oklahoma governor's office from advocacy groups, foreign governments, and religious leaders. Allen's attorneys filed a last-minute motion in federal court seeking a stay based on claims that evolving standards of decency prohibited execution of individuals with significant cognitive impairments. The 10th Circuit Court of Appeals declined to grant a stay. The United States Supreme Court denied certiorari on January 10, 2001. Gloria Jean Leathers' family members attended the execution. In statements to the press afterward, they expressed that justice had been served and they could begin to find peace. Allen was pronounced dead at 9:21 in the evening on January 11, 2001. She was 41 years old. Her execution marked the end of a legal journey that lasted 12 years from sentencing to death. The Clemency Board's 4-1 vote became a focal point in subsequent policy debates. Oklahoma executed 10 individuals in 2001. Allen was the only woman. If the clemency process is designed to catch cases where mitigation was overlooked, what does a near-unanimous denial signal that the mitigation was insufficient or that the process itself resists intervening? Texas Board of Pardons and Paroles. Clemency Decision Log, June 2013, shows unanimous denial in McCarthy case, June 2013. Kimberly McCarthy's attorneys filed a final clemency petition with the Texas Board of Pardons and Paroles. The petition outlined her drug addiction history, traumatic childhood, and rehabilitation efforts on death row. It included letters from family members and a prison chaplain. Prosecutors filed a response emphasizing the brutality of Dorothy Booth's murder and McCarthy's lack of remorse during trial. The Texas clemency process is opaque. Board members vote by written ballot without public hearing. Votes are not disclosed individually. On June 25, 2013, the board announced a 7-0 vote against commutation. Governor Rick Perry reviewed the decision and declined to issue a 30-day reprieve. The execution proceeded the following evening. Booth's daughter attended the execution and gave a statement, afterward describing 15 years of waiting. She said the finality brought relief, but did not erase the loss. McCarthy's family members were also present. They issued a brief statement expressing sorrow for both families. Between 1977 and 2013, Texas executed 500 individuals. McCarthy was the 13th woman. The time from sentencing to execution, 14 years, is above the Texas average, but below the national median. When an execution occurs after more than a decade of appeals, victims' families live in prolonged uncertainty. Does that delay serve justice by ensuring thoroughness, or does it inflict additional trauma by extending the legal reckoning across years? British Foreign and Commonwealth Office Diplomatic Note, 2019, requests executive clemency review for Linda Carty, 2019. The British Foreign and Commonwealth Office submitted a formal diplomatic note to the Texas Governor's Office requesting clemency consideration for Linda Carty. The note cited her British citizenship, alleged consular notice violations, and concerns about the quality of her trial representation. It requested that Texas not schedule an execution date without allowing further legal review. Texas officials responded that Carty had exhausted her appeals and that consular notice claims had been litigated and rejected in federal court. No execution date was set. Carty remains on death row with ongoing advocacy from UK-based human rights organizations. Her case has been featured in British media and documentary films, generating public pressure on both governments. Joanna Rodriguez's family members have made fewer public statements in recent years. In a 2017 interview, Rodriguez's mother expressed frustration that the case remained unresolved nearly 2 decades after the crime. She stated that every new legal motion felt like a denial of finality. Erica Shepard's case entered a new phase in 2020 when her federal habeas attorneys filed a motion for DNA testing of evidence that was not analyzed at trial. The motion argued that advances in forensic science could establish her lesser role in the offense or identify alternative suspects. The district court has not yet ruled. Tiffany Moss's appellate attorneys filed a voluminous brief in the Georgia Supreme Court in 2023, arguing the trial court erred in allowing self-representation without a competency evaluation. Oral arguments are pending. If the conviction is reversed, the case will return to Gwinnett County for a new trial. 4 women, Carty, Shepard, Moss, and Frank, remain on death row. 3 states, Texas, Georgia, and Louisiana, have not executed them despite years of opportunity. Does that extended delay reflect procedural diligence, state ambivalence about executing women, or a system where finality is more aspiration than practice? Death Penalty Information Center. Execution Database, updated. 2024 confirms. June 26, 2013, as date of last black woman executed in U.S. 11 years have passed since Kimberly McCarthy's execution. No black woman has been executed in the United States since June 26, 2013. 3 women died: Wanda Jean Allen in 2001, Frances Newton in 2005, McCarthy in 2013. 4 remain on death row. The last execution date of a black woman stands as a documented milestone, an endpoint that may or may not mark a shift in policy or practice. Clemency boards in Oklahoma and Texas have granted commutations at historically low rates. Oklahoma granted clemency in 1 death penalty case out of more than 100 petitions filed between 2000 and 2020. Texas granted 1 commutation in the same period, not for a woman. Louisiana's de facto moratorium has persisted for over a decade, driven by litigation and drug procurement challenges. Georgia's pattern of not executing women has held for nearly 80 years. The 4 women on death row occupy different procedural stages. Antoinette Frank is in federal habeas review after nearly 30 years. Linda Carty exhausted direct appeals and habeas, but continues clemency advocacy internationally. Erica Shepard has pending forensic motions. Tiffany Moss is in direct appeal with claims about self-representation. Their statuses reflect the variability baked into capital procedure. Identical death sentences can yield execution, commutation, indefinite delay, or eventual reversal. Victim families in all 7 cases have expressed a desire for finality. Some found it in execution, others have waited decades without resolution. The memorial for Dorothy Booth includes a plaque in Lancaster, Texas, reading, "Justice delayed but not denied." Joanna Rodriguez's mother keeps a photo album of court hearings, each date marked. Imani Moss's extended family holds annual remembrances on her birthday. The law provides mechanisms for accountability. It does not, however, guarantee swift conclusion. If the death penalty exists to deliver decisive judgment, the record shows something more complex. A patchwork of state-specific rules, appeal durations that can span multiple decades, and outcomes shaped as much by geography and era as by offense. The rarest defendants, black women, move through this system under heightened scrutiny and paradoxical obscurity. Their cases test whether equal protection is a constitutional promise or a procedural hope. Oklahoma Department of Corrections Memorial Ledger, 2001. Final entry for Wanda Jean Allen. Case closed. Evening lights dim along the corridors of death row facilities in 4 states. In Oklahoma, the H-Unit log contains a final entry dated January 11, 2001. In Texas, 2 separate entries mark September 14, 2005 and June 26, 2013. In Louisiana and Georgia, the ledgers remain open, names listed under active status. The question of what comes next hinges on variables outside the courtroom. Executive clemency power remains the final lever, but its use is rare and unpredictable. State legislatures debate abolition, courts rule on protocol challenges. Meanwhile, 4 women wait. Their cases may conclude with execution, commutation, or death from natural causes after decades of confinement. The outcome cannot be forecast with certainty. Legal scholars have noted that death sentences for women, especially black women, tend to provoke public discomfort and prosecutorial hesitancy. Juries may be more willing to convict but less willing to recommend death compared to male defendants. When they do recommend death, appellate scrutiny intensifies. This dynamic does not amount to leniency. It amounts to inconsistency. A system that imposes identical punishment but delivers wildly different outcomes based on demographic characteristics undermines its own claim to impartiality. The 7 cases documented here are not representative of all capital cases. They are, however, illustrative of the procedural realities faced by the rarest subset of condemned defendants. They show how mitigation claims succeed or fail, how appeal postures stretch across decades, how clemency boards vote, and how victim families navigate the long wait. They reveal the distance between the statute's promise, finality, and its practice, prolonged uncertainty. The courtroom doors close, dockets are filed, board votes are recorded, memorial services are held, and somewhere in Texas, Louisiana, and Georgia, 4 women continue to live under sentence of death, uncertain whether the system will ultimately carry out that sentence or let it lapse into indefinite delay. This is the record. The names, dates, filings, and outcomes are verified. The law's machinery moves slowly. Its results are uneven. The rarest sentences test whether justice is a principle or a variable, whether it bends toward equity or fractures along lines of state, gender, and race. The answer remains written in pending appeals, unscheduled execution dates, and the quiet entries that close a ledger or leave it open. The last docket stamp is dated, the file remains active.